So now we are going to discuss on anticipations. These sections from 29 to 34. It comes for anticipations. Okay. Okay. So they are very simple, and we can understand very easily. So section 29. So I'm again saying that these are my own notes, which I prepared for you for preparing for exams, and these are my wordings, and sometimes I've written as it is. So please read the exact wording from the Patent Act book, so that you are much sure that there is no mistake what is being said and what is being presented here for you. And then you can make your own notes, or I have made it here so that it is very easy for you to memorize and remember those. So section 29, anticipation by previous publication. Okay, so it says, 1, all patent published does not anticipate. Okay, so all patent published doesn't anticipate. So what are the conditions under which it doesn't anticipate? 2 says, non-anticipator if published patent, if published matter was obtained from him. Okay, so what you need to say, that say for example, a patent was published, and then during the examination another patent was found, and it is going to kill your patent under the prior art condition. But if you can prove that this patent that has been identified in the search process was wrongfully obtained from him, okay, without his consent, but as soon as he came to know about this, you file the patent, okay, and he made the application for patent as soon as he came to know about the publication before the date of application. This section not applicable if invention was worked commercially before priority date, excluding for experimentation or reasonable time purpose. So this doesn't apply if the invention was worked commercially before the priority date. Means if the invention was available in the public domain and it was commercially being worked out, it was sold in the market, or it has a manufacturing industry. So this section doesn't apply. This section what it says, that if I file a prior art which is going to kill my application, but if I can prove that that prior art was wrongfully obtained from me without my consent, and what I did, that as soon as I came to know that this this patent was being filed, I also filed the patent, and this is the same patent, and because he has filed the patent before me, and therefore it is becoming a prior art. Okay, this is a scenario. And then invention filed by contravention of right of person invention used or published after filing that without consent. Okay, invention filed by contravention of right of person or invention used or published after filing date without consent. So after the filing date, okay, after the filing date, if it is published or the invention is used, so that does not also become anticipation publication. So whatever condition mentioned here, it means that if these are the conditions, then those kind of publication will not be considered as prior art. So this is the meaning. So in simple language, section 29, what it says, that if I file a patent on 1st of Jan, and then after my filing date, invention file condition published after filing date, after the filing date, something was published or something was used by other person without my consent, okay, and those kind of document will not become a prior art for me and will be nullified, means control will not consider those. And if I can prove that the publication that is hampering my case was wrongfully obtained from me and they file it, but as a steps I immediately filed a patent when I came to know about it. So that need to be proved. Okay, so this is under section 29. So on this section, what are the question can be asked under section 29? You may be given some scenarios, and then you may be asked some questions. So this could be question in the paper 2 or paper 1 also in the multiple choice question also. So which they may give some section 29, section other section, and they say that if not anticipated, if the published patent was wrongfully obtained, is under which sections? So it is under section 29. So they may give section 29, 30, 31. But wrongful obtained patent is not a prior art under which section? So it is under section 29. So this kind of question can be asked. Or in the paper 2, the question can be asked like they can give a scenario that that a person comes to you saying that there is a prior art published which is direct killing my application. It is direct prior art, but I want to tell that this prior art was obtained wrongfully from me, and even it was published without my consent. What should I do? So this is a scenario. Then you need to write, according to section 29, this prior art will not be from the anticipation, because and then you need to prove that it was wrongfully obtained. So this is the answer you need to give. Okay. Section 30, anticipation by previous communication to government. So if you communicate your experiment or your data to the government for the investigation of the invention, for the purpose of investigation of the invention, then those communication will not become the prior art. So not be from the part of anticipation, meaning that if a client comes to you, the question is given. So questions are asked in the paper 1 also. Paper 1 question could be like this. It says that flowing is not an anticipation. So they may say communication to the government, communication to the print media, communication to the general, communication to the friend. So many options were there. So if it is communicated to the government before filing date, even if it communicated to the government, then it doesn't become the prior art. Anticipation by public display. Okay. So public display means you have published articles or you display in some seminars. So many times this question is asked for the universities people, and they say that I worked on this, but I published my article in journal article. I went to this conference and I made a poster presentation, and this was there. What should I do? So regarding this, what it says, display or use with consent of true and first inventor. That is one criteria. Okay. Or publication of any description after the display or use in exhibition notified by government. So if you want to make any poster presentation, so that poster presentation that exhibition should be from central government, should have been organized by central government. Central government organizes that exhibitions and you display there, and after that the poster display, something is published. 31D says use of invention after exhibition notified by central government without consent of true and first inventor, without the consent. So the exhibition was organized by central government, and in that exhibition you displayed the poster or you displayed your product, and that product was used without your consent. Someone has started using in the market or doing and displaying. Description of invention in paper read by true and first inventor before learned society. So if there is a society, I mean to say that if you're working on catalyst, there's a catalyst society, there are some general societies are there, and they will present your topic, you read it, and with the consent that is get published in the society journals articles. Then what need to happen? If the application is made by true and first inventor within 12 months. So you have a time period 12 months within which after this activity happens, you must file the patent application. And if this kind of prior arts comes to you, so this does not form anticipation. Okay, anticipation. So this is the condition 29, 30, 31. So 29 is very simple. 29 is it says that if the patent was wrongfully obtained, but and then you file a patent. So that patent will not be not for anticipation. And if the invention was used, if it's a product and it is being used after the filing date and without your consent, then also it doesn't in anticipation. If it is communicated to the government, then also it doesn't form anticipation. And if section 31 says that if you display in any exhibition organized by central government, and after the exhibitions within 12 months you file the patent, then that exhibition display will not hamper your patent prosecution. That means that is not anticipation. And after the display in the government organized exhibitions, someone else publishes the data. So, for example, you develop a very novel way of solar battery, and then that gets published in all the major newspaper here and there, and then that is get displayed in the news channel everywhere. Now you're famous personality that you have developed something solar and battery or those kind of anything. But what you need to do that immediately within 12 months you must file a patent on those. Otherwise, if you file patent after 12 months of this activity, then what will happen that anyone can oppose. So, for example, I made a solar battery, and there was an exhibition organized by central government on January 1st, 2019. And then I became famous throughout the country, throughout the world as an inventor of the solar battery, and I get many recognition, awards, everything happening within this 12 months. And I got so much engrossed in all this that 12 months passed, and now it is February 2020. Okay. Now I displayed it. I have not filed the patent, and now I filed the patent in when after 12 months 2020. Then someone sees and he remembers, the priority date is filing date is February 2020, but I remember seeing something about this in news article, in paper, on a news channel about this in June 2029. Okay, then that person can go and file pre-grant oppositions, or if he's a person interested, he can file post-grant opposition and saying that this has already happened, already published, already used, and then your application is killed. So that care has to be taken, and questions are asked based on this scenario, as I discussed now. That this is a scenario what need to be done, and your application killed. So be careful that in such scenario you need to advise your client that please file the patent within 12 months. If you file within 12 months, then everything is saved. Then for example, it is only 1 or 2 days left for completion of 12 months. Okay, then what to do? Then he's in problem. Then you can ask that please give the whatever detail is there, PowerPoint, everything, whatever is there, and then you can quickly draft and file at least a provisional application you can file, so that your priority date is saved. Within 12 months you file, and the priority date is saved, and then after that you can go ahead with the complete specification. But you need to save that, you need to file patent application within 12 months. That is the date. So many questions are asked based on the scenario in first paper, as objective questions in the second paper, as the case may be. Okay. Next is section 32. Okay, anticipation by public working. Okay, so if it is so that for the purpose of reasonable trial, for example, you manufacture a road roller, so you want to test it. So road roller can be tested only by working in the public only, so everyone is going to see that. But if it is for reasonable trial, you work there, okay, and everything is happening with the consent of patentee, then within 1 year you need to file the patent. Otherwise, after 1 year, then it becomes anticipation. So if you can prove that this public working was within 1 year, I have filed the application, then this is not anticipation. Section 33 says Anticipation by user publication after provisional specification. So if we have filed a provisional specification and after that date, if it is being used, published, or anything happening, then controller cannot refuse to grant, revoke, or invalidate. So therefore, it is always advised, like I gave a scenario that your client wants to meet and show some sample. So sample to another client, okay, business client. Then what you need to do? What you need to do is like file a provisional specification before the marketing executive goes to a client and displays a sample to them. Okay, and so that that display will not hamper. So sometimes it may happen that you give a sample to the client on some date, and you have not informed the patent attorney that you did this act, and that person, he took that sample with some date, or he may have some meeting date, something later with that, and he has anything that you gave the sample on this date, and he took to the home, and then you see that no application has been filed, and then you file later on after that sometime, then same client can oppose the application of patent, either pre-grant or post-grant application, saying the prior use of the document. Therefore, anytime marketing executive goes to sell sample or give sample, he must communicate to the patent attorney, and patent attorney can quickly file any provisional specification, and then they should go. Okay. And section 34 says no anticipation if circumstances are only as described in section 29, 30, 31, and 32. So 29, as I said, 29 is regarding that wrongfully someone filed the patent and then you also filed the patent, and that is the case. Section, what is section 30? Can anyone say? We just read. What is section 30? Section 30 is communication to the government. And what is section 31?
31.
Public display.
Public display. And then you file within 12 months. And public display is that in government organized exhibition only, not any organization. You cannot organize your own exhibition and display. That exhibition should be government organized. And 32 is like public working for purpose of reasonable trial only. For reasonable trial, you have displayed in public and then you file a patent. So then there is a 12-month window period to file your patent application. Okay. So this is what it says. So anytime a document comes to you, someone presents the documents regarding this invalidation or revocation or post-grant opposition, pre-grant oppositions, then you need to see that evidence that he has produced, if it is falling under any of the section 29, 30, 31, 32, or 33, means used or published after the provisional or complete specification. So that is one way to defend your patent application from getting revoked or invalidated. Okay, so this is one tool you can use. So this is a good section, section 29 to 34. So after this, we'll move to the secrecy provisions. So we'll have to take some break for 5-10 minutes.